Hi, I'm Dave Boer. As you're probably aware, our auto insurance laws in Michigan underwent significant changes when no-fault reform was passed in June of 2019. Our team at Boer Insurance Group wants to make sure that our clients understand the changes and how they apply to them. So in this video, we will talk about personal injury protection order of priority rule changes. First of all, let me describe what PIP coverage is. PIP stands for Personal Injury Protection, and this is the coverage on a Michigan auto insurance policy that pays for your medical expenses, rehabilitation, home and vehicle modifications to accommodate a disability caused by a car accident, attendant and skilled nursing care, lost wages for up to 3 years if you can't work while you recover from an injury, survivor's benefits, burial expenses, and replacement services. If you have this coverage on your policy, PIP will pay for these expenses regardless of who caused the accident. Even if you caused the accident yourself, the PIP coverage on your auto policy will pay these expenses. And as a covered person, PIP coverage pays whether you're a driver of a car, a passenger in a car, or if you're hit by a car while riding your bike or as a pedestrian. The issue we're addressing in this video is who is covered by the PIP coverage on your auto insurance policy. The no-fault reform legislation has changed this considerably, so let's review how it used to work and how it works now. Prior to the no-fault reform law being passed in 2019, the PIP coverage on your auto policy would cover you as the named insured, your spouse, your resident relatives, which are your family members who live with you, and even a driver or passenger of your vehicle who didn't have coverage under any other policy as a named insured, spouse of a named insured, or as a resident relative of a named insured on an auto policy. Under the new PIP Order of Priority rules, the only people covered by the PIP coverage on your policy are you as the named insured, your spouse if residing with you, and your resident relatives, which again are your family members living in your home. Nobody else qualifies for PIP coverage under your policy anymore. To look at this another way, let's review the PIP Order of Priority chart. Under the old rules, if you're hurt in a car accident, you go first to the policy on which you are a named insured, meaning the auto policy that is written in your name. Here's an image of a declarations page from an auto insurance policy with the named insured, John and Mary Doe, highlighted. Typically, the named insured is the person listed on the declarations page, usually an individual or a couple. If you aren't a named insured on an auto insurance policy, you would go next to the policy of your spouse. If you don't have a spouse with an auto insurance policy, you would go to the policy of a family member with whom you live. This usually applies to children living with their parents. If none of the first three apply, the next order of priority is to seek PIP coverage under the policy of the owner of the vehicle involved in the accident, whether you were a driver, passenger, or hit by that vehicle as a pedestrian. If the owner of the vehicle doesn't have PIP coverage, you would next seek coverage under the auto policy of the driver of the vehicle involved in the accident. Again, whether you are a passenger in that vehicle or hit by that vehicle while you're riding your bicycle or as a pedestrian. So, as you can see, under the prior rules, there was almost always a way to find PIP coverage somewhere for just about everyone. And unlimited PIP coverage was mandated, so no matter where you found coverage under the order of priority rules, it would be unlimited coverage, meaning there was no maximum limit to how much would be paid for your medical expenses from an auto accident. And even in the rare situation where an injured person didn't find PIP coverage somewhere in the order of priority, such as a pedestrian injured by a hit-and-run driver, the Michigan Assigned Claims Plan would provide unlimited coverage. The order of priority rules have changed dramatically, so now the order is: first, you go to your own auto insurance policy to receive PIP benefits. Second, if you don't have an auto insurance policy in your own name, you go to your spouse's policy. Third, if you don't have a policy in your own name and neither does your spouse, or if you don't have a spouse, you would seek coverage under a relative with whom you live. Again, typically this scenario involves children who live with their parents, but you could claim PIP benefits on the policy of your sibling or other relative that you live with if you don't have your own policy. After that, your next stop is the Michigan Assigned Claims Plan, which now provides a maximum coverage amount of $250,000 instead of the previous unlimited coverage. As you can see, the fourth and fifth steps from before have been eliminated. Here are some sample scenarios to be concerned with. children living away from home. If you have children who no longer reside with you, but have use of your vehicle, under the old order of priority rules, they would not have qualified for PIP coverage under number 3 as a resident relative, but they would have qualified under number 4 because you were the owner of the vehicle that they were injured in. Under the new rules, they still would not qualify as a resident relative if they don't live with you, but now there is no rule number 4. So they would have to seek PIP benefits from the Michigan Assigned Claims Plan with a maximum coverage limit of $250,000. As a point of clarification, a child who is living away from home temporarily, such as while going to school, may still qualify as a resident relative under your policy, so they would be covered for personal injury protection by your policy. The claims adjuster will have to determine if the child is a resident relative and qualifies for PIP coverage at the time of the accident based on what address is on the child's legal documents, such as driver's license, voter's registration, and other legal documents, where they actually live most of the time, where they intend to live when they're not at school, whether they have a room and property at your house, and other factors. If they are found to qualify as a resident relative, then your PIP coverage should apply to them. Sometimes, after a child graduates from college, starts their career, and rents an apartment, they still have possession of a vehicle owned and insured by their parents. This is a situation where, even though they're driving a vehicle that is insured, they are not covered for personal injury protection because they are no longer a resident relative. In this case, it's critical that the child purchase an auto insurance policy in their own name. As a named insured on their own policy, all their policy coverages, including PIP, will cover them in their own vehicle, a friend's vehicle, a rented vehicle, or as a pedestrian or bicyclist if they're hit by a car. Next, we have an unrelated person injured while driving your car, or as a passenger in your car, or when hit by your car. Under the previous rules, these injured parties could seek PIP coverage under your policy based on Order of Priority Rules 4 or 5 if they didn't first qualify for coverage under Rules 1, 2, or 3. But because Rules 4 and 5 were removed by the No-Fault Reform Law, these people can no longer obtain PIP benefits under your policy. A policyholder who allows a child that does not reside with them, a friend, or a significant other to drive their car needs to be aware that this important part of their auto insurance no longer applies. And your PIP coverage also no longer applies to these people when they are passengers in your car. However, that doesn't mean all is lost. If any of these people have their own auto insurance policy with PIP coverage, or if they live with their spouse who has PIP coverage, or if they live with a relative who has PIP coverage, they would be able to seek coverage under those policies. If none of that applies, they would seek benefits up to $250,000 from the Michigan Assigned Claims Plan. So what can you do to fill the gaps that were created by the No-Fault Reform Law? The best solution is always to be a named insured on an auto insurance policy. That simply means that the policy is written in your name. Being a named insured provides the broadest benefits of an auto insurance policy, and as I previously mentioned, all the coverages afforded by the policy, including the PIP coverage, follow the named insured wherever they go in the United States and Canada. So whether the named insured is in their own car, or a friend's car, or a rented car, or hit by a car while riding a bike or as a pedestrian, their auto insurance policy covers them. If a person doesn't have a car to insure, but they want to have PIP coverage, liability coverage, and uninsured motorist coverage for when they drive or are a passenger in a vehicle they don't own, or when they're hit by a car as a bicyclist or pedestrian, they could purchase a named non-owner policy. And finally, for a person who doesn't have their own auto insurance policy or a named non-owner policy, and who doesn't qualify under someone else's policy as a spouse or resident relative, they can seek PIP benefits up to $250,000 from the Michigan Assigned Claims Plan if they are injured in a car accident. That concludes our video. I hope it was helpful. We realize this is a complex subject, so if you have any questions about how the order of priority changes will affect you, or have any concerns about your policy, please schedule a call with one of our agents. Thank you.